communication strategies around union organizing. I'm Megan. I'm with the Home Care Alliance Massachusetts. I'm the Meeting and Education Coordinator. I just wanted to go over a few things before we begin. First of all, I am going to record this webinar just in case anyone has technical difficulties or you need to hop off early, because we know that this is an hour, but there's always a likely chance it might go a little over because of the topic. If you have any questions throughout the time of the webinar, it will be held until the end, and since you're on mute only, you can type in your questions in the questions box or the chat box, and then we'll be sure to address it at the end of the webinar. Tom has given me permission to get the handout from him, so I'll send that out as well. So if you're interested in receiving that after the webinar, feel free to email me with any questions. Without further ado, I'm going to introduce Tom Revenue, who is our speaker today. Tom Revenue is a shareholder with the law firm of Seton, Peters & Revenue. He has successfully litigated a wide variety of labor and employment law claims before state and federal courts and administrative agencies. He represents and counsels employers in all aspects of labor and employment law, including employment discrimination, union avoidance, unfair labor practices, workers' compensation, drug testing, privacy issues, OSHA compliance, the Americans with Disabilities Act, unemployment compensation, personal policies and employee handbooks, restrictive covenants, hiring, discipline and discharge, and other general employment issues. Mr. Revenue is a frequent trainer and lecturer on the topics of discipline and discharge, safety and health issues in the workplace, employment discrimination, and labor law issues. So without further ado, I'm going to hand it over to Tom.
Thanks, Megan. Good morning, everyone. Today I'm going to talk about employee communication strategies around union organizing, and just for further background, I have also been involved in union organizing drives throughout the country. That's where my practice is taking me. And obviously, with regard to home care, there's been a focus or a target by the SEIU on your industry. And through today, I'm going to talk a little bit about the history of unionization, as well as the history of organizing, particularly with regard to the PCAs, and then get into some of the strategies that you can use to remain union-free. To talk a little bit about the history of unionization in the United States, the National Labor Relations Act, which is the law that allows employees to organize, was passed in 1935. And by 1954, we had the highest percentage of workers who were unionized in the country. Roughly about 35% of the workers in the country were unionized. But beginning in the late 1970s, the percentage of union workers drops, and you can see that it starts to drop fairly dramatically. And what you will hear from unions is they will say that they win more elections than they lose. But the bottom line is they are still losing members, and right now the union density is at its lowest percentage since the National Labor Relations Act was passed in 1935. Now, I think there are a number of reasons why unionization has dropped and dropped fairly dramatically. And perhaps just to step back in history, in 1935, the National Labor Relations Act was really one of the first laws designed to protect workers and worker rights. But as we got into the 1960s, into the 70s, in the 80s and 90s, there have been a whole slew of employment laws that have been passed to protect workers. In the 60s, we had Title VII, we had the Age Discrimination and Employment Act that were passed. In 1970, we had OSHA that was passed. And as we get into the 90s, the Americans with Disabilities Act, the Family and Medical Leave Act was passed, and there are a number of other laws that I'm not mentioning that were passed on the federal level, not to mention a variety of states have also passed various laws protecting workers. With regard to the history of PCA unionization, I just put up on the screen here a number of states that have gone through organizing drives with regard to the personal care attendants. And there was organizing that took place in 2007 with Oregon. Obviously, Massachusetts has its own home care workers that were unionized in 2008, where 22,000 workers were unionized. Missouri, 12,000 PCAs vote for unionization. Wisconsin, 5,500 PCAs vote for unionization. Connecticut, another 6,700. I think there's an interesting stat here that of the 6,700 PCAs that were unionized, only 1,200 voted for unionization, 365 against, which means the vast majority didn't even participate in the election, but yet the union represents all 6,700 PCAs. And some of you may have heard what has been called the Michigan experiment with regard to personal care attendance. Governor Granholm, who was the governor of Michigan back in 2005, signed a bill into law that allowed the unionization of home health workers. And in Michigan, 43,000 home health workers were sent mail ballots. Only 20% of those who received the mail ballots actually participated in the election. And those who voted actually voted in support of the unionization, and the union ended up representing all 43,000 workers. All of those workers were forced to pay union dues, paying 2.75% of their income, which generated roughly $6 million in union dues per year. The average wage was $8 an hour when Governor Granholm signed the bill into law in 2005, and Governor Snyder, who came into office much later in 2012, essentially signs a bill that reversed this legislation and took the home care workers out of the union. And at that time, the average wage had not changed for the home care workers, and there had been no change in benefits either. Once Governor Snyder signed the bill, 80% of the workers dropped out of the union. So the union went from having roughly 44,000 workers represented by it to 10,000. And of course, the union lost between $4 to $6 million per year in union dues as a result of Governor Snyder signing this bill. But then, of course, in Massachusetts, there's been a opposite things happening. In 2012, a 3-year agreement, collective bargaining agreement, was signed that essentially included a 90% raise over 3 years of the contract. So the starting wage for the PCAs went from $12.48 an hour to $13.38 per hour. In addition, under the contract, there was a $1 million fund for PCA training opportunities beginning in the second year of the contract. And by the third year of the contract, there was also $1.5 million of paid time off benefits. And of course, the PCAs also have health insurance. Nevertheless, as you know, the SEIU has been focused on several industries in what they call this fight for $15. And they believe that $15 is a living wage and that all workers should receive a minimum wage of at least $15 an hour. And they've been focused on a variety of industries, but predominantly fast food and home care. And frankly, the fast food industry has had most of the focus up until recent, but of course on April 14th, so next week, the SEIU is starting their Fight for $15 campaign in Massachusetts. And what do we foresee happening? Well, if the fast food Fight for $15 campaign is indicative, what we expect is that with regard to the SEIU's campaign with home care, it will include employee walkouts. It will include petitions signed by employees complaining about wages or terms or conditions of employment. And of course, for those employers that are not careful with regard to what they do or don't do, they may face the possibility of unfair labor practice charges being filed against them. And we're going to talk a little bit about how to avoid unfair labor practices in a moment. If there are franchisors who are on the call today, be cognizant of the fact that the SEIU has filed unfair labor practice charges not only against the franchisees, but also the corporate franchisor. even in those scenarios where the franchisor really has no control over the employees at issue. And in fact, some of you may have read in the Wall Street Journal or in other newspapers that McDonald's corporate has been brought into a number of unfair labor practice charges that were actually filed against their franchisees, but the NLRB is claiming that they have such control over the franchisees that they're responsible for the unfair labor practices at issue. So what do? Well, obviously our best defense is to be prepared if you're facing some of the issues that come out of this fight for $15 an hour. Which really brings us to the bulk of this 1-hour webinar, which is how do we remain union-free, or how do we avoid some of the issues that come out of an organizing drive or this fight for $15 an hour. And we think there are really 3 strategies to remaining union-free or avoiding the unfair labor practices, and that is prevention, education, and response, how you actually respond to the union activities. And strategy number 1 is really the prevention, and this is the area that I'll probably cover the quickest on today's webinar. But in essence, it's practicing Management 101 skills, or HR 101 skills. In essence, it means that as an employer, we have a commitment to positive and preventative employee relations. When it comes to organizing drives, the overwhelming majority of union campaigns are issue-driven. The union, when they meet with your employees, will try to find out all the issues, all the skeletons in the closet, and create issues for you as an employer. And we believe that if an employer can remain issue-free, you can remain union-free. Now, am I suggesting that you're going to remain completely issue-free day in and day out? Absolutely not. What I'm getting at is that you have a commitment as an employer to address issues when they arise and to address those issues on a timely basis. If you remain issue-free as an employer, frankly, you eliminate the need for unions. The unions are no longer relevant because you're dealing with your employees directly and addressing their concerns as they arise. So how do we remain issue-free as an employer? Again, as I mentioned, it's practicing HR 101 or Management 101 skills. And what that means is that you develop and implement policies, procedures, and practices that are designed to anticipate and respond to employee issues and concerns before they manifest themselves into employee complaints, turnover, or low morale. In other words, you look at, do you have an employee handbook? Does your employee handbook address the issues that employees may have? Do you have an open door policy? And if you have an open door policy, are you actually practicing that open door policy? Or is it really just on paper and your door's always closed and employees never have the opportunity to talk to you? When you look at remaining issue-free, there are 3 fundamental principles. Number 1, as we just talked about, you have employment policies and procedures and practices that are effective. But second, you have an effective two-way communication between management and employees. And that's something that I think everyone on the call today should think about. Do we really have effective two-way communication with our employees? Or is it going in one ear and out the other? The more that you communicate with your employees, the less likely they're going to feel that they need to go outside the organization to be heard. I often give the analogy or the example of campaigns that I'm involved in when it involves an employer with 3 shifts. And as you can imagine, when an employer has 3 shifts, oftentimes union organizing starts at the 3rd shift. And it's pretty easy to figure out why. Because on first shift, everybody knows what's going on because upper management is working most of first shift. And usually there aren't too many issues on second shift because there's an overlap between management and second shift. But by the time you get to the third shift, the third shifters feel left out. They feel like the ugly stepchild. And frankly, oftentimes the supervisors that are working the third shift also aren't in the loop with regard to communication. So one way to remain issue-free is to make sure that you're effectively communicating with all shifts, first shift, second shift, third shift. And there are ways that you can communicate with your employees, whether it's by email, whether it's by newsletter, whether it's by periodic meetings with your employees. It could be holiday parties. But the more communication you have with your employees, the less likely you're going to have issues, or certainly issues that lead to a union organizing drive. And the third fundamental principle of remaining union-free is to have an effective management team. Oftentimes when an organizing drive starts, one of the first things I do when I'm representing a client is to sit down and talk to their management staff and to their supervisors to find out exactly what's going on. And oftentimes I find or discover during these interviews that some of the organizing has occurred because there is a supervisor who wasn't trained in basic HR 101 or management 101 skills. In other words, what I discover is the client has what I call a boss. And a boss is a double SOB spelled backwards. It's that manager or supervisor that's an equal opportunity jerk, that is always miserable and makes everybody around them miserable. You can never please that individual. They never listen, and it's their way or the highway. And those types of supervisors often create a lot of the issues with regard to a union organizing drive. And frankly, those types of supervisors oftentimes create legal liability for employers in a variety of manners, whether it's EEOC charges, discrimination charges, or the like. So remaining issue-free is essentially making sure that your management team are properly trained in HR 101 skills. And finally, practicing positive employee relations means that you as an employer recognize that your employees have options. And those options mean that if their issues and concerns are not handled internally, they'll go outside the company. And they'll go outside the company, either they'll leave and find another job, they'll file charges with the EEOC, they'll contact the Department of Labor, they'll go see a plaintiff's lawyer to complain of discrimination, or they might go see a union to address their issues. So positive employee relations means that you recognize that your employees have options and you'd rather hear their concerns and their issues and address those issues and concerns before they actually go outside the organization. Strategy 2 of remaining union-free is educating your workers, because I believe that the more employees know about a union, the more likely they're going to say, no, I don't want a union. And some of you on today's call may wonder, well, gee, should we really be talking to our employees now about unionization if we're not facing any organizing? And when that question is raised in seminars that I conduct in the live format, I often ask the seminar attendees, you know, how many of you have kids? How many of you have nieces or nephews or grandchildren? And virtually everybody raises their hand, and I ask the audience, how many of you heard that you should talk to children at a young age about the use and abuse of drugs and alcohol. And everybody raises their hand and says, yeah, we've been told that. We understand that if we do discuss that issue with our children, they're less likely to abuse drugs and alcohol in the future, or certainly they're going to be aware of the potential consequences. And it's the same thing with regard to unionization. You shouldn't be afraid to talk to your employees about what it means to belong to a union, because the more they know, the less likely they're going to be interested. Think about the question, what is a union? And oftentimes, seminar attendees struggle to come up with the definition of what a union really is. And it's frankly fairly easy. A union is a business. And we often forget that they are a business. And a union is a big money business. And they get their money through membership dues, initiation fees, penalties and fines, and membership assessments. I'm going to give you a few examples. The SEIU Local 199, which is the union that is seeking to organize home care workers in Massachusetts, last year they had $12.5 million in revenues. Their local president made $133,000 a year. And there are other officials within that union that were getting paid in excess of $100,000. Then when you look at international union, the SEIU International, the international president received $614,000 last year in wages, and there are approximately 10 other union officials that were paid in excess of $200,000. And I point those out just to remind audience members that unions are a big money business, and they charge membership dues, and those membership dues are used to pay those large salaries. And in some instances, the local union will charge initiation fees for employees to join the union. They can penalize and fine employees if they don't abide by the union rules. Anytime an employee joins a union, they agree that they're going to be bound by the union constitution. And each union has their own constitution, and those union constitutions can be anywhere from 50 pages long to 150 pages long. And it's a set of rules that they are bound by. Other things to think about with regard to unionization is sometimes unions engage in what are called salting tactics. And essentially what a salt is it's an individual who is getting paid by the union, who in turn is seeking to gain employment with an employer. And the U.S. Supreme Court has said that that is lawful activity. And there are two types of salts. There's the overt salt and there's the covert salt. And the overt salt is someone who engages in confrontation. In other words, they confront the employer and force the employer to make mistakes, and then once the employer does the wrong thing or says the wrong thing, the union files unfair labor practices against the employer. The covert salt is the individual that's undercover and is engaged in a salting campaign against the target employer to gain information, to recruit others for support so that they can in turn initiate an organizing campaign and try to unionize your workforce. And if they can't do that, then perhaps they'll file unfair labor practices to put pressure on you as an employer, whether it's economic pressure because you pay to fight the unfair labor practice charge, so that ultimately that economic pain is so great that the employer in turn eventually voluntarily recognizes the union to stop the charges. if you're faced with a salting campaign, the most important thing is that you control your response. So think about how you would answer some of these questions if somebody came into your office and said, I'm here to apply for a position, and by the way, how do you feel about the fact that I'm an organizer for the SEIU? And you wonder, how are you going to address that question? Or if they say, if I'm hired, I'll be trying to organize your employees. Or, why does your company provide substandard wages and benefits to employees? And these are all tactics that I've seen be used in the Fight for $15 campaign, where unions will go into your offices and make comments like this or similar to this, and you need to be careful with regard to how you respond to these comments. So if you're asked, how do you feel about the fact that I'm an organizer for the SEIU, your focus should be on the job that you're hiring. We're here to hire somebody that has the skills and abilities for the job that we're hiring. That's why we're here, and divert the attention from the fact that the individual may be an organizer, because you can't use that in your decision making on who to hire or not hire. Now keep in mind that the Fight for $15 often includes walkouts by your employees over wages and benefits. And it often includes other protected concerted activity, where employees are asking for wage or benefit increases for all their employees, or there's picketing that occurs outside your office. And what I would suggest is that if you have any of this activity that takes place, before you take any adverse action against your employees, consult with legal counsel with regard to what is the appropriate response, because oftentimes your initial reaction may lead to an unfair labor practice charge, because you can't take adverse action against an employee who is asking for wage or benefit increases when that individual is speaking on behalf of all employees. And you certainly can't take action against them if they're picketing outside your office during non-working time. So keep in mind that SALTs are engaging in activities that are intended to provoke a retaliatory response by you, the management. And before you take adverse action, or before you engage in a retaliatory response or say the wrong thing, what I suggest to clients is use the administrative timeout. In other words, take a moment to get yourself out of that situation so that you can carefully reflect and carefully evaluate what or how you should respond, and to ensure that it is, in fact, a lawful response. The key is not to overreact. So I wanted to share just a little bit of information with regard to how unions organize. And on this slide, you'll see what I have titled the old organizing timeline. Because as of April 14th, the National Labor Relations Board will be implementing its quickie election rules. And I'll talk about that in a few moments. But typically, when it comes to organizing, organizers or the union engage in organizing activities for 6 to 12 months, where they're gathering information about the company or the industry, they're forming an organizing committee, they're secret card signing, and then eventually they file a petition for an election. The union needs cards signed by 30% of those employees in the proposed bargaining unit to get an election. And typically when they file for a petition, they're going to have 70 or 80% of the employees in the proposed bargaining unit who have actually signed cards. Here's where the big change has occurred. If you look at the top of the page, you'll see a section that says critical period 42 days. Under current NLRB rules, if an election is filed between now and April 14th, that petition will be processed, and typically the election will not be scheduled for 42 days after the petition has been filed. Once the new rules take effect on April 14th, an election could take place as quickly as 10 days. So you can imagine under the current rules, you would have essentially 6 weeks to campaign and discuss with your employees the pros and cons with regard to unionization. Under the new rules that take effect on April 14th, you could have as little as 10 days, which is another reason why I suggest that you talk to your employees up front about the pros and cons of unionization so they have an understanding of what it means and doesn't mean, and so that they know your personal views with regard to unionization. The other thing that I'll point out is these union authorization cards can be a little tricky. And you'll see that this is a sample authorization card. And it says authorization for representation. And at the very top it says, I authorize the International Brotherhood of Teamsters to represent me in collective bargaining with my employer. And then it has the name, address, city, the name of the employer, and other fill-in-the-blank information requests. Oftentimes what organizers will tell employees is, this is just an information card. This is just a card that you fill out so you can get more information. It's not a big deal. And oftentimes the language, I authorize the union to represent me in collective bargaining, is not at the top of the card, but it's at the bottom of the card in very small print. Once an employee signs this card, however, they have essentially authorized the union to represent them for purposes of collective bargaining. And it's not just an information card. It's actually where the employee is signing their rights over to the union to represent them. What are the issues that may lead employees to seek out a union? Well, it's kind of interesting because if you ask supervisors what are the issues that lead employees to seek out a union, there's a pretty consistent response. Supervisors will say money and benefits, money and benefits, money and benefits. Well, if you ask employees, well, why did you seek out a union? Oftentimes they say, well, it's to have a voice in the workplace. It's for dignity and respect because our supervisors don't listen or management doesn't listen. Or it's because we simply want to be recognized for our efforts. In other words, oftentimes it's not about money and benefits, but it's about how the employer treats them. And I will tell you that in the vast majority of union organizing campaigns that I've been involved in, oftentimes it's not about the money and benefits, it's more about the dignity and respect or how the employer is treating them. Survey after survey will say that as long as you're paying your employees competitive wages and benefits in the industry, all they want is a pat on the back to be recognized for what they're doing. During a typical organizing drive, once the union has enough cards signed, oftentimes they will claim that they represent a majority of employees and they'll send a letter to the employer demanding recognition. And the bottom line is, as an employer, if you receive one of these letters, you are not obligated to recognize the union. You can frankly tell them, go file a petition for an election. A couple other things to keep in mind is that assume you have 100 employees in the proposed bargaining unit. So you have 100 employees The union needs 30 cards signed for the petition. And the union needs 50% plus one of the votes. So if there are 30 cards necessary for the petition, if all 100 employees vote, 51 votes are needed. But assume only 3 people vote, only 2 votes are needed. And if 2 vote yes and 1 vote no, who does the union represent? Well, they represent all 100 employees. And at that point, it's too late to say I told you so to the employees who didn't participate in the union or in the election. Final strategy is how you respond to the union. How do you counter union arguments? So the first question I have for those of you who are on the line is, how many of you would know what to say if an employee came to you and asked, what's the company's position on unionization? My guess is most of you wouldn't know how to respond. And so we'll talk about that in a few moments. But responding to union organizing means that you recognize that you have rights under the National Labor Relations Act, that the employer can talk about unionization with their employees, provided that it's done in the right manner. So if employees ask, what's the company policy on unions? Here's a sample. The right to operate union-free carries with it an obligation to establish and maintain a work environment where unions are unnecessary. And what that means is that we as an employer maximize personal development and growth. We have direct communication with our employees. We recognize individual achievement and merit. We provide competitive wages and benefits. We treat employees fairly with dignity and respect so that there is no outside interference from strangers. And what does the law say with regard to what you can say or not say to your employees? Well, there's a provision under the law that essentially gives employers free speech rights. And that's Section 8C of the National Labor Relations Act, which essentially says that you as an employer have the right to express any view, argument, or opinion or disseminate it, whether it's in written, printed, or graphic or visual form, provided that such expression does not contain a threat of reprisal or force or a promise of benefits. And you can spend a lot of time reading this, and it gets a little confusing trying to understand what they were intending when they wrote this law. But essentially what it means is that you as an employer can talk about your foe. So remember the acronym FOE. You can talk about your foe. What that means is that you can talk about facts with regard to unionization. You can talk about the fact that the international president for the SEIU made $644,000 last year. You can talk about the fact that the local president made $133,000 last year. You can talk about the facts if there are unionized employers in your area that went out of business. You can talk about those facts and the fact that the union wasn't able to save those jobs. You can also talk about examples or experiences. And those examples or experiences could include that you belong to the union or belong to a union at one point in time and they didn't do anything to help you, that they came around once every 3 years to negotiate a contract and you never heard from them. That all they did is they took your union dues from your paycheck month after month, but they didn't do anything to help you. And you can express your opinions, provided that your opinions do not contain a threat. So you can tell your employees, well, we don't think the union has anything to offer. We think the union, all they want are your union dues. And you can talk about those opinions, provided that there are no threats. Here's an example of what 1 year of union dues cost. And this was actually a table that we set up at a client site that was going through a union organizing drive. And as you can see, in this example, this is what $400 of groceries was worth at the time we took the picture. And the union dues at that time were $420 each year. And so this is a graphic that tells employees, well, you can spend $400 on union dues, or you can spend $400 on something that you really want. And that's an example that really drives things home for employees. There are limits on what you can do, and those limits are, I remind seminar attendees, remember the acronym TIPS, T-I-P-S. And what that means is that when you're talking to employees about unionization, you can't threaten them. In other words, you can't threaten to take away money if they vote for the union. You can't threaten that you'll shut down your business if they unionize. You can't threaten that you're going to put them on a bad shift. You're going to take things away if they unionize. You can't threaten them. Additionally, you can't interrogate them. Well, what do I mean by that? What I mean is you can't ask them questions with regard to the unionization effort. You can't ask questions, are you interested in the union? Who's interested in the union? Who's showing up at the local tavern to listen to what the union has to say? You can't ask any questions with regard to whether or not they're for or against the union. If you did so, that'd be an unfair labor practice. Having said that, oftentimes employees will come to you and they'll volunteer what has occurred or what the union is saying to them. And you can always listen to your employees. In fact, you can tell your employees who come to you that we can always listen to what you have to say, but we can't ask questions. And oftentimes employees will understand what's going on and they'll share everything with you. And finally, or in addition, you can't promise employees that they'll do certain things if they vote for or against the union. You can't promise that they'll get $1 an hour pay increase or that you'll make sure they get the shifts or the hours that they want to work if they vote against the union. So you can't make promises. And then finally, you can't spy on them. In other words, if you know the union is engaged in an organizing drive and you know that the employees are going down to the local bar to meet with the union, you can't go down there and show up and see who's meeting with the union at the bar. So you can't spy on them to see who's engaged in union activity. So what I tell seminar attendees is remember TIPS, because if you don't, the union will spit on you. And if they spit on you, it'll be the pits, because that means they filed a bunch of unfair labor practice charges against you. And of course, I'll be pissed because that means you didn't listen to this segment of my program. When it comes to the organizing drive, what your employees need to be aware of is that organizers will say anything to get your employees to sign a card. They'll tell the employees that the union card is just to get more information. It's only an election card, just give us a try, or you can always vote the union out. Go ahead and sign it, it's not a big deal. So if an employee asks a question, should I sign the card, you could certainly say we recommend you don't for some very good reasons, and then explain to them that they need to get the facts and make an informed decision, because signing a card is like signing a blank check. It's a legally binding document with unknown costs where the employee who's signing the card is giving their rights up and they're assuming obligations. And those obligations mean that they're assuming that they're going to be complying with the union constitution and the union bylaws. And of course, there may be unknown uses of that card. You can tell employees that signing a card is like signing a blank power of attorney. That when they sign that card, they're sacrificing their right to be treated as an individual, and that they're authorizing a stranger to make decisions concerning their wages, benefits, and working conditions. Additionally, employees also need to be aware of collective bargaining, and they need to be aware that what really goes on during contract negotiations. Oftentimes employees think that if they vote for a union, that means that they're automatically going to get wages and benefits, and that's not true. What the law provides is that as an employer, you have an affirmative obligation to meet with the union at reasonable times and confer in good faith with regard to wages, hours, and other terms and conditions of employment. But that obligation does not compel either party to agree to a proposal or to make a concession. In other words, when it comes to collective bargaining involves give and take negotiations. It means that to get something, the union oftentimes has to give something up. And the only chips the union has to bargain with are wages and benefits, as well as other terms and conditions of employment. And so make no mistake that collective bargaining is an adversarial process. The last point I wanted to talk about is union solicitation and distribution of literature. And just a few things to keep in mind is that when it comes to employees versus non-employee union organizers, there are different responsibilities. If employees are engaged in union talk or solicitation and they're doing it during working time, you can certainly tell your employees that, get back to work. Work time is for work. They can certainly engage in this type of activity during break times, but not when they're actually working. With regard to distribution of literature, as long as you are enforcing this rule across the board on everything, you can tell employees they're not allowed to distribute literature in work areas. Again, provided that you're enforcing that rule uniformly across the board. When it comes to non-employee union organizers, they don't have the right to interfere with your employees' work, and they certainly don't have the right to distribute literature in working areas. And they're not entitled to interfere with your operations. And if they do, you can certainly tell them to get out. And then finally, oftentimes the question is raised, what if the union business agent shows up at your site? What are your obligations? What do you do? And how do you respond? And the first thing to keep in mind is that if the union business agent shows up at your office, they certainly have no right to access your office. But if they do walk into your front office, be prepared. And if you're going to speak to that individual, make sure that you have another witness who's observing exactly what's going on. And you'll see on this slide, I also note that don't accept anything from the union. I mean, you can certainly accept a business card, but don't take any other documents from the union. And the reason I suggest that is oftentimes the union will want to present you with authorization cards, the cards that we talked about earlier. And if you accept those authorization cards from the union and you start looking at those authorization cards, what the law says is that you have in essence voluntarily recognized the union by looking at those cards, because at that point you know which of your employees have signed cards and haven't. And so if the union presents you with a stack of cards that a majority of your employees have signed and you start looking at those cards, you will have voluntarily recognized them and the union will have become the representative of your employees. I intentionally left a few minutes left on today's webinar for any questions. And so if you have any questions, I'm happy to answer them now. And Megan, if you could read the questions, that would be helpful if there are any.
Absolutely. We actually have a few. So the first one was from towards the beginning of your presentation. Two-way communication means creating effective means of the employees talking to us. What about that?
Absolutely. I mean, if your employees aren't communicating with you, you're not going to learn what their issues are, and you can't address them. So it is a two-way street. It's not only management talking to the employees, but also the employees talking to you. And there are a variety of ways where you can talk to your employees or communicate with your employees or have your employees communicate with you. And there are some in home care that use employee surveys, where the employees will fill out surveys with regard to how they think things are working from a business standpoint. And you can use that tool, you can use those surveys to effectively respond to that communication or the employee concerns. That's a great point.
The next question is about employee attitude surveys. It sounds like you kind of just sort of addressed it.
I did.
All right, so next one is, if I suspect an employee or applicant of being assault, is it okay for me to ask them that directly?
I would not ask that question if you suspect they are assault. And the reason I wouldn't ask that question is because once you ask that question, they're going to identify themselves as a union assault, and then any action that you take against them, they will use that as a basis for why you got rid of them or why you disciplined them. It's all because of their support for the union. And so I wouldn't ask the question, are you a union assault, or are you interested in the union? And frankly, simply asking that question would be considered an unfair labor practice. Remember, I talked about interrogation. You can't ask questions of an applicant or an employee whether they support a union or not. So I would not ask that question.
All right, we have a few that are asking about the slides, and yes, Tom will be sending them to me, and I will forward them along to all of you. Let's see, we have a lot. All right, so the next question is, how does this impact social media policy regarding posting information about employer?
Great question. As many of you may be aware, the National Labor Relations Board has been focused on an employer's use or an employer's social media policies. And there's a whole wealth of information with regard to when a social media policy is lawful or unlawful. But you certainly cannot prohibit employees from engaging in what's called protected concerted activity as it relates to the use of social media. So I'll give you a few examples of what I mean. There are plenty of cases involving the use of Facebook where employees are on Facebook and they're talking about wages and benefits with their coworkers, or they're talking about their supervisors, and they're talking about those items in derogatory terms. And in those cases, oftentimes the employer learns of that, and they take an adverse action against the individual or individuals for complaining about wages and benefits or their supervisors on Facebook. And when they do so, they're violating the National Labor Relations Act because they're taking an adverse action against an individual for engaging in what's considered protected concerted activity. Because under the National Labor Relations Act, employees have the right to talk about their wages and benefits, to complain about their wages and benefits, and as an employer, you can't take action against them for doing so. With regard to having an effective social media policy, I'll leave it at this, that's a topic that we could spend an entire hour on. And with regard to your social media policies, there are resources online that can talk about what should or should not be within your social media policy, and I'd certainly be happy to answer any questions offline to seminar attendees as well.
All right, so next question is, there was a video out there called The Little Green Card. Is it still effective as an employee training tool?
Yep, great question. And I think the video that the attendee is referencing is a video called Little Card, Big Trouble. And the video is probably 20 minutes long that a lot of employers have used as a training mechanism for their employees. And I think it is an effective tool. I think it is still effective because it educates your employees what it means to sign a card. And it's a video that has gone through litigation, and the National Labor Relations Board has found that that video is lawful. It's a lawful mechanism of communication. And that video is offered through an outfit called Projections. And there are other videos out there as well that you can get from other resources. But that video that the seminar attendee referenced is still out there, and I think it is an effective tool.
Next question are, what are the implications of a NLRB charge?
Great question. There could be a variety of implications with an NLRB charge, and it depends on the type of unfair labor practice charge that was filed. I'll start from the beginning. If you receive an unfair labor practice charge, you'll have to respond, and you'll have to retain legal counsel to respond to that charge. As far as if the charge is found to have merit, it's going to depend on what type of activity you've engaged in. So if an employer has unlawfully terminated an employee for engaging in protected concerted activity, the ramifications are that you would have to reinstate that employee with back pay, and also post a notice within your work site for 60 days notifying employees that you violated the National Labor Relations Act, that you've reinstated the individual, and that you've paid back pay, among other things. And so that is one ramification of an unfair labor practice if it involves an unlawful termination. Some unfair labor practice charges may simply, if they're found to have merit, may simply just mean you'll cease and desist in your actions. So some charges entail you have unlawful employee handbook policies. In other words, some of your policies in your handbook prohibit employees from engaging in concerted activity. Well, if you haven't enforced those work rules, but they're out there, the NLRB will essentially order you to rescind those policies, modify those policies, and post a notice that you won't do it again. So there are a variety of ramifications with regard to an unfair labor practice charge. It really depends on what type of charge that you have, but those are a few examples.
All right, next question is, if an organizer comes into a business and leaves an envelope with cards in it at the reception area, labeled for an employee in HR, is that acknowledgement?
Well, I would say it's not, and I don't think that the union representative would do that, because at that point they've lost complete control if they just leave it in an envelope and then they leave the building, because I would imagine many employers would just throw those cards away and not look at them. But I think from a practical standpoint, I don't see that happening. Where I see it happening and have seen it happen is where the business agent is actually physically handing those cards to a member of management who can actually recognize the union by looking at those documents. So if it was handed to the receptionist, I think they'd be hard-pressed to say that, you know, the receptionist has bound the company to recognizing the union. If it's handed to somebody of upper management, then that answer is different. Great question.
Next we have, how do we handle any disgruntled former employees?
Well, that's a loaded question because I'm not sure what the disgruntled employee is doing or not doing. And sometimes you can do some things and other times you can't. I've had organizing drives that really were the result of disgruntled employees who have sought to unionize the employer more as retribution because those individuals were laid off than anything else. And I think it just depends on what the former employees are doing. I mean, if they're defaming the company, then you might want to look at sending a letter telling them to cease and desist. But again, I think that's a question that should be raised with Labor Council if that's going on, so that you can determine what you can effectively do or not do in responding to that individual or group of individuals.
Looks like that's the end unless anyone has any more questions. All right. Well, thank you, Tom, for a fantastic presentation. Again, this was recorded, so if you need access to it, just let me know. And once Tom sends me the slides, I'll be sure to send it out to everyone as well, because I know a lot of you were asking for it. And when should we expect the PowerPoint? Tom, do you know when you can get that to me?
I'll send it to you later this morning.
All right, so you should get it by the end of the day today. And all right, so I think that's everything. Thank you again for listening in. If you have any questions, feel free to contact me. And thank you very much. Have a great rest of your day.
Thanks, everyone. Bye.